And in a controversial, rather blindsiding order, a Kerala Sessions Court has granted bail to a 74-year-old activist and poet in a sexual harassment case. While granting bail to the man, the Kerala Sessions Court said that the offence would stand in the court of law as the complainant was wearing a quote-unquote sexually provocative dress. Hence, a case of sexual harassment prima facie will not stand. The court also observed that the activist is 74 years old and physically disabled and hence could not have forced himself upon the woman, which was the charge. Now, what are the implications of this kind of an order for women, and how do you define a sexually provocative outfit? To speak more on this, I'm joined now by Karuna Nundy. Let me play out for you a conversation I had with her earlier today. Karuna, great to have you on the show. Just how the sexual harassment law can be diluted as per this judgment because of what the woman is wearing, and who defines what is a sexually provocative dress?
Also, what's interesting is that he seems to be saying, it's a bit unclear as to what this gentleman is saying, but in this case, in para 10 of the judgment, what the court has said is that the photographs produced along with the bail application by the accused, mind you, would reveal that the de facto complainant herself is exposing two dresses which are having some sexual provocative one, right? Now, it seems like he's saying that she had a range of clothes and there was some sexually provocative dresses. So, frankly, I think that it's really important because guidelines have been passed by the Supreme Court in Aparna Bhatt, and they're very important words that were said. For example, the Supreme Court starts, Justice Ravinder Bhatt's judgment, he starts by saying, a woman cannot be herself in the society of the present day, which is an exclusively masculine society, with laws framed by men and with a judicial system that judges feminine conduct from a masculine point of view. This is Henrik Ibsen, which is, of course, a very, very long time ago. But the reason it's been cited is because this is what the Supreme Court has said is frequently the case in our jurisdiction in this day and age as well. The point is that when, despite various judgments of the Supreme Court saying that consent is central in these cases, despite very clear guidelines being passed as recently as 2021 to judicial officers, despite years and years and years of judgments saying that if you are a sex worker, that your consent is still going to be honored by the law. You have people coming up with their own prejudices against constitutional morality, and why should these people, I feel,
Karuna,
I feel that there should be at the very least training, and
the
and then, for example,
is,
the judge in Bombay who made these terribly egregious judgments in POCSO, as far as I recall, like she wasn't continued, that she wasn't kept on as a High Court judge. And I feel like there has to be very clear action. There should be warnings, there should be trainings perhaps, and then after that people should just be dismissed because this is not acceptable at all.
The bigger concern is, and of course this is a court of law which has given this observation, but it is in a sense a reflection of what a lot of people think in society, and they still think it. And there is no legal redress to that kind of thought. And that, to me, is also a very big concern.
I think the point you're making is a very important one, which is that sometimes people use it as an excuse. And they say that, look, our courts come from society, and then therefore, inevitably, they will reflect the prejudice in society. But the courts exist in order to address any prejudices in society that lead to crimes, or that lead to torts, or that lead to civil wrongs, right? So if you have somebody with state power saying these things, then what you're doing is that you're strengthening the wrongs against women and other disadvantaged, people with other characteristics that are sometimes disadvantaged in society. You're strengthening them in the law, and that's a huge problem. And it cannot be tolerated, I feel.
Now,
like
you know, in this
extremely
particular
important.
case,
Yeah.
this was at in a court in Kerala, and then it's now, you know, been dismissed. Anticipatory bail has been given. One doesn't know if the case will be challenged in a higher court and a higher court, so on and so forth. But one of the points that was mentioned was the delay in filing the FIR of 2 years with no reason given. And that is something we see very often in these sexual harassment cases. We saw it in the whole Me Too movement as well, when women are asked again and again, why don't you say it just there and then? Do you think there is no cognizance of those reasons in law, that why a woman at that point feels that she simply cannot speak up?
If you look at this case, because it's not that it was just dealt with in this manner because of the delay, it was many other things were said about the woman. Isn't that self-explanatory with regard to the delay? Is something I would ask myself. But in addition, I think the jurisprudence around the world is rightly moving towards an understanding that classically, in these cases, there is a delay because women are grappling with themselves. They are saying, was it my fault? Was it my fault because I talked to him and he was a colleague? Or is it my fault because I smiled too much? Or did I not, is it my fault because I have one dress or two dresses that are sexually provocative? The point is that there is jurisprudence around the world moving in a different direction because it reflects the reality that our justice systems have not reformed to the extent that they should to bring swift and certain justice to women and to perpetuate the rule of law in these cases, as has been recognized by the Supreme Court in 2021 in the judgment that I just cited. So to say that a woman is hesitant, I mean, I think that there's no reason to not ask for reasons. I think it's okay to ask for reasons, but it's also really important to take cognizance of the fact that there are lots of structural and legitimate reasons why women don't complain. Now, there is guidance to, we are doing a case that where we are pleading and looking to advance jurisprudence to say that there is guidance, for police officers internationally, that delay happens due to these reasons, due to the difficulties in the justice system and due to the difficulties in society, due to some victims who still are shamed, including in this judgment.
You're right. Karuna, I want to understand, for our viewers, and this would actually be of use, if a woman wants to take on someone who she thinks has sexually harassed her and her offender, how do you do it in a way that you ensure that you get justice? So, for example, do you need to have clear answers to a question like, why did you take so long? And the sequence of events. How do you ensure that these legal loopholes don't leave you out of the justice you deserve?
I'm so glad you asked me that question. When you are assaulted or sexually harassed, make sure that you keep a contemporaneous record of what happened. Either tell somebody in authority in writing, or at the very least, tell someone in writing as things happened. Because that will be evidence of sterling quality as time goes on. Even if you're not filing the complaint then and there, keep that evidence. Secondly, when you're filing the FIR, make sure that very clearly what happened to you and the ingredients of the offense are factually set out. And if it's obviously you must be truthful, and that's extremely important, because otherwise you're compromising not only your own case, because it will come and bite you later, but also others. But you can make sure that everything that happened that was a part of, say, Section 354A is set out. Don't forget anything. The third thing is that if you're grappling with, inner demons with regard to the delay, right? If you're saying that I didn't have the legal support, say that my family was maybe going through something, if you were feeling hesitant for other reasons, if you were saying that I'm the only breadwinner and this was a situation where I was working in a company and the person at the workplace harassed me, then say that, explain the delay.
Yeah.
And I think these three things are quite important, but I think the most important thing is really the contemporaneous evidence.
Right. Keep some kind of a record of it in writing as soon as possible, even if you want to act on it later. Thank you so much, Karuna Nundy. Always a pleasure speaking with you.